Hello, and welcome to another one of our short teach-ins from the Tenant Farmers Association. I'm George Dunn. I'm the Chief Executive at the Tenant Farmers Association, and this teach-in is part of a series which seeks to shine a bit of a spotlight on some topical issues that are being faced by the tenanted sector of agriculture. And it's part of our library, which features webinars and news updates from the previous weeks. And today, we're very pleased to be hearing from Adriana Vaux, who's one of our expert rural surveyors here at the TFA. And she's going to be talking us through the topic of dilapidations. What are they? And what can I expect my landlord to claim for at the end of tenancy? So before we start, I should say, but we are absolutely delighted to be supported by Oxbury Bank, who have agreed to sponsor the whole of our 2023 virtual program of events and teach-in sessions. For those who may be unaware of Oxbury, they were formed in 2021, formed by a collaboration of bankers, farmers, and technologists. And they are the UK's only bank which is 100% dedicated to serving farmers, food producers, and the rural economy. So big thanks to Oxbury. So moving on to today's teach-in on that topic of dilapidations, I should say that we are recording this in the summer of 2023. So everything we cover today is correct at the time of recording. So if you need any specific advice on individual circumstances, we recommend that you call the TFA head office and speak to one of our team of advisors, including Adriana. So I'd like now to introduce you to Adriana, who, as I said, is one of our specialist rural surveyors here at the TFA, and she will talk you through the key points to consider when dealing with dilapidations. So welcome, Adriana. The floor is yours.
Good afternoon, everyone, and thank you, George, for that introduction. As George alluded, today I'm going to be talking about dilapidations. So first off, I thought I'd give a quick introduction to explain that dilapidations are very different depending if you have an FBT tenancy or an AHA. And just as a quick FYI for your information, FBTs are under the Agricultural Tenancies Act 1995, and AHAs are under the Agricultural Holdings Act 1986. So today I'm going to be starting off with AHAs and dilapidations. So dilapidations are a depreciation in the value of the holding caused by the tenant. And these are often brought about where tenants have not been upholding their maintenance and repairing obligations of the tenancy agreement. So an example of this could be where a tenant has put up a new shed and it's either never been looked after, so is now dangerous, or the tenant has taken it down and not made good the area. So any items which need replacing because a tenant has either caused it damage or not repaired it would be considered dilapidation at the end of the tenancy agreement. And there's this very specific process by which a landlord would have to pursue in order to claim dilapidations. So a landlord would have to provide the tenant with a written notice under Section 83 of the 1986 Act within 2 months after the end of the tenancy agreement. And this notice must specify the nature of the claim. Claims can then be settled within 8 months, and if it goes on any longer than that, then it has to be settled by arbitration. So there is, in assessing compensation, the general rule for assessing compensation is that dilapidations are first assessed by reference to the cost of putting right the issues. This usually means that the cap is capped by the loss in the value of the landlord's reversion. So typically, the landlord would need to prove how much it will cost to put the issue right, and the tenant will have to prove how little the problem which the landlord is saying the tenant has caused to the landlord's property. So the tenant will have to prove that it's not causing the bigger issue that the landlord is saying it's caused. And the measure of compensation is the cost as at the date of quitting the holding and making good the dilapidation, deterioration, or damage to the position required by the tenancy agreement. And a calculation of the cost of necessary remedial work will be required to restore the property to the required standard. Examples of dilapidations are such as gates missing, lengths of hedges not being laid or trimmed, length of ditches not being cleaned, falling down tenants' buildings which have been left behind, or buildings taken down by the tenant and the area not put right. So with FBTs, the situation is very different. Unlike the Agricultural Holdings Act 1986 Act, the 95 Act makes no provision for dilapidations. It is actually down to the parties to agree to their own clauses and how any disputes over this should be resolved. If parties have not included a dilapidation clause and there are no repairing obligations within the FBT, the landlord can pursue a claim for damages against the tenant, which is for the value of the loss in the value of its reversion. However, where there is a repairing clause but no dilapidations clause, which is actually quite common, the landlord can pursue the tenant during or after the end of the tenancy for not fulfilling those repairing obligations. This value can not only include the depreciated rental value, but also any void period required while works are being undertaken. And there is no generic way a landlord can do this, as it very much depends on the dispute mechanism within the tenancy. However, typically it would go to arbitration or court. But either way, this is a very costly process to both the landlord and tenant. So it's incredibly important that the tenant knows and understands exactly what the repairing obligations are for the tenancy and adheres to them. So I just want to leave some important take-homes. For FBT and AHA tenants, it is absolutely vital that tenants know and understand their repairing obligations and fulfill these well ahead of when you're planning to retire or the tenancy agreement if it's a fixed term comes to an end. And there are a few important take-homes for FBT tenants. It is very, very important that you have your tenancy agreement checked by a professional before you sign it. And as TFA advisors, we're able to do this for you. A good tenancy makes life far less stressful for a tenant if the right clauses are in place, such as a good dispute mechanism, which allows matters to be referred to arbitration rather than, for example, court, as this means that someone who is well educated in agriculture law is involved rather than, say, a regional judge who may know next to nothing about agricultural tenancies. You also, negotiating on repairing obligations before signing the tenancy agreement is a must, such as trying to negotiate that the tenancy follows that of the 2015 model clauses, as these are most beneficial to tenants. But also, if the landlord is insisting on a put and keep repairs, a prospective tenant must consider, is it actually worth the risk of signing the tenancy, especially if the holding is in really bad condition to start with. And finally, having a schedule of condition in place before you sign the tenancy is so important, especially for those who are having to leave the holding in no worse condition than it was at the start of the tenancy agreement. However, generally a schedule of condition gives everyone a detailed picture of how the farm was at the start of the tenancy. And this enables tenants to have a strong position when a landlord may try and say something's dilapidated when it was at the start of the tenancy, if the tenant wasn't legally obliged to put it into good condition in the first place. If a tenant has to put everything into good condition, then a schedule of condition isn't so important because everything on the holding needs to be put and kept in a good condition and repair anyway. Thank you.
Thanks so much, Adriana, for that. So clearly quite a lot to think about if you're a tenant coming to the end of your agricultural tenancy, and a real need there to take some advice. There's a few questions I just thought I'd raise with you that would be interesting to those who are listening in. So let's say I've come to the end of my tenancy and I have converted some grassland into arable at some point in my tenancy. Do I have to put that arable land back into grass?
This is a great question, and one we actually are asked quite often. So this very much depends on whether consent was obtained from the landlord before you change the field from arable to grass. If consent was obtained in writing, then it's what's called a tenant's improvement. However, you need to check whether this consent has conditions attached to it, which state that at the end of the tenancy, you may have to put the grass back into arable. However, often we see situations where no consent was ever obtained from the landlord, and therefore it's what's called a tenant's fixture. And you as a tenant will have a legal requirement to put the land back to how it was when you first took on the tenancy. But you need to be careful, because if this was grass back to arable, you need to make sure that you're complying with the environmental impact assessment agriculture regulations, which came into force in 2006. And the purpose of this was to protect the environmentally significant areas from being damaged by agricultural works. And therefore, permanent pasture, which has been down for 15 years or more, which is over 2 hectares in size, would need the consent from Natural England before changing it back to arable. And this is something, if you did need help with that side of things, then our policy advisor would be able to assist further on that.
Okay, and another thing which I might have done through the course of my tenancy is maybe to put up some buildings where I don't necessarily have the consent of the landlord for those buildings. And when I come to retire, those buildings have no particular value to me. Can I just simply leave them behind?
And this is also a great question, which we receive a lot of the time. Buildings which do not have the written consent of the landlord, as I've explained, are tenants' fixtures. But even if you have verbal consent, that is still not written consent, and therefore it would be treated as a tenant's fixture. It is only written consent which make those buildings a tenant's improvement and therefore eligible for compensation, and you do not need to take them down. However, as a tenant's fixture, you can offer them up to the landlord to purchase at the end of the tenancy, but there is no legal obligation for your landlord to do that. And therefore, in the context of this question, whilst a tenant can leave their fixture behind, there is the strong possibility that the landlord may try and claim a dilapidation against you by saying that they have reduced the value of the reversionary interest. And this very much depends on the age of the building. So, for example, if your father, before you put the buildings up, and these are 60, 70-year-old buildings, and they're falling down, then it's highly likely that yes, they are causing a reduction in the value to the landlord's reversionary interest, and the landlord would have a claim. So it depends on the nature of the buildings. The landlord will need to prove this. However, it is likely that, as I said, if they're potentially dangerous and cost more to repair than to pull down, then the landlord would have a case against the tenant for that. So yes, a tenant is likely to need to remove the buildings and make good the area in which they're sat and around.
Okay, so last question for now. Clearly, there could be a sizable difference between what a landlord expects to get for dilapidations and what a tenant is prepared to pay for dilapidations. So what can I do if I don't agree with the claim for dilapidations that the landlord is trying to make against me?
Yes, it's really important that if you don't agree, then you should be arguing your case. And depending on the terms of the tenancy as to what your dispute mechanism is, but for the purpose of this question, we'll assume that it's arbitration. So if your landlord wishes to pursue a claim for dilapidations, which a tenant wishes to contest, the landlord will need to refer the tenant will need to refer the matter to arbitration within 8 months of the end of the tenancy. And even though a tenant has applied for the appointment of an arbitrator, parties should continue to try and negotiate in order to reach a settlement, because arbitration should always be used as last resort due to the excessive cost. It is highly advisable for tenants to have some form of legal expense insurance in place, such as our own TFA's legal LPG farm business protection insurance for such a scenario, as litigation can cost tens of thousands of pounds. It is a matter, if the matter is referred to arbitration, then both parties will need to have either an agent or a solicitor acting on their case, because you'll be having to put down a watertight case to argue that you are correct. And the arbitrator will be going on the basis of the case and evidence placed in front of them. An arbitrator's award will be legally binding. It's very difficult to appeal award, which is why it's very important to put such a good case with professionals in place. So you need to be prepared for that, which is why it can cost a lot of money. So it's definitely more ideal to try and reach a settlement before it goes to that stage. And it's incredibly important, as I mentioned before, that you need to really know the responsibilities which you have within your tenancy agreement, so that you can then do the works in your own time and at your own cost and try and prevent a dilapidations claim. It means that you can pick your own timescale which suits your budget, and therefore it is absolutely imperative to prepare for retirement a long time ahead of the date which you want to walk away from the farm.
Okay, Adriana, thanks so much. Clearly, there's a lot to take in here for end of tenancy matters relating to dilapidations. And if you are watching or listening and you've got more questions around your individual position, you can become a member of the Tenant Farmers Association and get some specific advice in your own circumstances. Currently, membership of the TFA is excellent value for money. It's only £249 per year. And this gives you access to dedicated advice, information, and support from our experts like Adriana. So for more information about the TFA and how we support all farmers in England and Wales on all the land that you don't own as a farmer, then why not visit our website? It's www.tfa.org.uk. And there you'll find information about our upcoming calendar of events, as well as our latest news, which is affecting your sector and all tenant farmers. We really hope you found this TFA teaching useful. And if you are watching this on YouTube, this teaching is part of our growing library on our YouTube channel. So let us know in the comments below what you thought about this little video. Don't forget to like and subscribe to the channel so you don't miss out on any of the new content as we post it. So thanks again to Oxbury for sponsoring our virtual program, and thank you for watching, and goodbye.